7 o'clock, I am going to call this meeting to order. All 5 of the regular zoning board of appeals members. So we do have a quorum. We're going to review and approve the minutes of the last meeting. May 30th of 2020. Well, you sent them out to us.
I sent them out.
Yes.
Saturday.
Everyone had a chance to review them. Any questions, any comments, anything that folks would like to bring forth?
Only thing I saw was the bottom of page 2, second last line. It says this is unusual application, it should be unusual.
Oh, goodness. All right, so we stand corrected on that?
Yep.
Anything else? With that correction, I will accept the motion to approve the minutes of the May 30th meeting.
Move to accept as written.
Second. Moved and seconded,
As written and.
as written and correct. Yep. Very good. All those in favor, please say aye. Aye. All those opposed? The minutes are approved. We are meeting tonight to address an appeal from one Jordan Smith. Jennifer, do you want to, can you give us a synopsis? Jordan came to you.
Jordan came to my office with the form of the Maine Medical Use of Cannabis Program, Inherently Hazardous Substance Manufacturing Facility, Local Authorization Form, in search of a signature from a town official or me as CEO. And my decision was not sign the form. I wrote my decision to him, and here we are for the appeal.
Very good. So the question then moves on to, does the Board of Appeals have jurisdiction to hear this appeal? It's certainly taking place in the town of Pownell. We do have some documentation from the prior code enforcement officer that this business has been in place since 2011. So yes, it's situated within our town's borders. Are there any other observations, comments that folks might offer along these lines? Sir?
Yes, I'll introduce myself for the record. I'm Jim Katsifikis. I'm an attorney with Perkins Thompson, and I'm here tonight representing.
Oh, I'm sorry, Jim.
That's okay.
Yeah.
Jim Katsifikis with the firm of Perkins Thompson. I'm here tonight as the board's attorney. So I'm a neutral attorney. This is an impartial board, and I'm your neutral attorney. I have not represented this, the code officer or anyone in this matter. The question of jurisdiction is this. Is this something that this board has the ability to hear? It's not just whether they're within the town. Your appeals are supposed to be from the code enforcement officer's decision, and your job is to decide whether there's any error in an order, requirement, decision, or determination made by the code officer or building inspector in the enforcement of this ordinance. There's nothing in this ordinance that talks about signing or deciding or allowing or refusing to sign a state authorization form. That's not a typical town function. This is something that comes up under state law. So there is a question as to whether the action appealed from actually is in the enforcement of this ordinance, and therefore whether you have jurisdiction. Certainly.
To our and I don't have my code book in front of me, but don't our regulations give for the BBA authority to hear appeals from any action or failure to act by the code enforcement officer?
To hear and decide where it's alleged there is an error in any order, requirement, decision, or determination made by the building inspector in the enforcement of this ordinance. And I'm quoting from section 207. That's at page 9 of your ordinance. And so one question that could be raised, I'm not saying it's determinative, it just is something to think about, is whether this decision appealed from is in the enforcement of this ordinance. Now, you could argue that the question that's being made is this use one that is grandfathered under your ordinance? And maybe you could bootstrap it that way, but there is that question.
Didn't
Not necessarily. There's nothing in here. Well, interpreted in the sense of there's no cannabis regulation in the town. It's not, there's no ordinance in the town, but we're talking about the zoning ordinance. This is true. This is true. So if you could bootstrap that, I'm just raising the issue for you to think about so that you can express how it is that this party, how this board would have jurisdiction over this matter. Okay, thank you.
Cliff, do you have any insight, that you'd like?
It seems to me that the code enforcement officer made a determination that she could not, on behalf of the town, represent the state that there was a previously authorized use by the applicant here
Mhm.
at that location. And it does seem that she was interpreting the state of town ordinances over the town's zoning ordinances over the years.
Yep.
And coming to that determination. So it seems to me that the board does have jurisdiction to decide whether that action, failure to act, whatever you want to call it, was proper.
Mm-hmm.
Under the zoning.
Okay.
I think that's not deciding the merits.
Right,
That's
right.
deciding whether we issue a decision.
Okay. All right. David, Phil, Dick, do you have any feelings on this matter?
I would agree with that, you know, if she was acting, as he asked for that to be signed, he was acting now.
Mm-hmm.
Maybe we're jumping ahead a little bit. I was just wondering if we have any information on this the grandfathering of this in the first place. I mean, historically, when did this happen and who gave it the okay? The commercial cannabis growing facility.
I think if we think we have jurisdiction, then I think I should do is hear the articles.
Right, right.
As to what their positions are.
Yeah.
On questions like that, it goes, who's right?
All right.
So an appeal has been filed. That portion is certainly straightforward. They're coming to us to review the ordinances and either issue a thumbs up or thumbs down so that they can proceed. So I think within the normal review of our ordinances and what we're charged to do, it would be my opinion that we do have jurisdiction. I'd be willing to, anyone opposes or? All right, I so move that we act in the capacity that we, the zoning board of appeals for the town of Albion, do in fact have jurisdiction over this matter. Seconded?
Yeah, I can.
All those in favor, please say aye.
Aye.
All those opposed? So we've determined that we've made the decision that we do in fact have jurisdiction. Does the appellant have standing in this appeal? Mr. Smith is a resident of the town of Powell. And again, everything has been done in accordance with the regulations in the filing for this appeal. So with that, we'll, yes.
He had his hand up.
Chair, two quick questions. Who is the appellant here? And the reason I ask is that part of the submission is that there's an LLC that is a party here, but the Royal River Botanicals LLC Limited Liability Company. And the appeal, though, was filed by Jordan Smith. So whose appeal are you hearing? Is it Jordan Smith who signed the appeal and on whose name this is brought? Or is somehow Royal River Botanicals LLC a party to this? And then the other thing is that this decision of the code officer was actually made in March. March 19, I believe, is the date that's on it. And the appeal was filed on May 14th. I think the appeals have to be filed within 30 days of the decision of the code officer. So there's just two things to think about. Who's the party who has standing? And then is this a timely appeal?
Taking the second of those first, is the Prairie Days jurisdiction for?
It's a threshold consideration. Well, you know, do you have jurisdiction over the subject matter that you've made that decision? Then the question is, do you have jurisdiction over the appeal because it was made in a timely manner?
So it's time.
Well, you could say that, but it's usually considered on its own.
The question of notice of finality of decision.
Right.
And how
That's correct. And that's something that the appellant has argued. I just raising the arguments that you can address them.
And then who the appellant is,
Mhm.
I understand Mr. Smith filed the notice.
And his name is on it.
And his name is.
Exactly. But they are separate legal entities, since that's why I raised the issue.
Both could be protected. Decision
Mhm.
of CEO, both have standing.
They could. It's just you have one appellant who filed.
Well, we'll hear from.
I understand. Okay, thank you.
Is Mr. Jordan Smith here? Sir, I'd invite you to come forward and state your case.
Right. Greetings, esteemed ZBA members. Thank you for having me here this evening. Thank you for everyone else for being here as well. My wife and I moved to Pownell 19 years ago. We bought our home here 10 years ago. We had our daughter here in 2018. My maternal great-great-grandparents are buried in the Merrill Road Cemetery. Between my wife and I, we have nearly 200 years of family history in this town.
By the way, have you seen the cemetery lately? I'm sorry. I didn't do
I
that.
have not.
It looks really good.
Yeah.
Oh, that's good to know. All right, so anyway, around the time we moved here, I started a little hardscape and sculpture company. Some of you may have noticed the little plaque that I made and donated for, well, somebody donated the plaque and then I donated the stone that it's in. That's right out by the flagpole here. I've done a lot of other projects around the town. By 2010, my hardscape business was failing because of the economic crash of 2008. It just wasn't happening anymore. At that same time, the state of Maine rolled out its first navigable medical cannabis program. I had went to school for horticulture and botany. I had a lot of experience working with plants. We thought this would be a good opportunity for us. So we got licensed by the state. We came to the town hall. We were given explicit verbal approval to operate. We requested a home occupancy license or a home occupation license rather. We were refused that. We were a legal business. We were a compliant business, both locally and on a state level, despite what anyone else may want to claim. Municipalities have no authorization, no control over home-based caregivers. So this is a good time for me to mention that in 2010, it was legal conduct of any licensed caregiver or card-holding caregiver, if you want to get specific about whether it's a license or not. Within their authorized conduct was what is now known as IHS extraction, which is what we do now. So, you know, all that's changed over the years is the paperwork surrounding that. So, anyway, I'll get back to some background on this. So anyway, I mentioned I got licensed by the state. We've received approval after approval, explicit verbal approval, implicit approval via 14 years of never anyone telling us we could not operate until the recent statement from Jenny, which by the way, was not a formal answer. So there's question to that itself. So, you know, that said, is Becky here?
Becky's right behind you.
Are you able to read or do you have access to the email from Natalie Bruns regarding, non-conforming use that was read at the April 22nd hearing?
All the board members have a copy of that.
Okay.
Or got an email.
So what she claims is, this wasn't even in my speech, you know, like, we're talking about grandfathering. We've been doing this for 14 years here in this town. Everybody knows this. This isn't up for debate. So in 2017, in two separate select board hearings, we were guaranteed our protection and safety in the future, including for our lab, because these hearings were specifically relating to cannabis moratoriums and ordinances. Now, it's also been pointed out by the town attorney, Natalie Bruns, that these ordinances, as she understands, only apply to adult use businesses. So we were promised that grandfathering in 2017. And again, not offered anything in writing. And I really want to stress, like, we met every requirement to receive a home occupation license. There's no reason we shouldn't have received that. It's not fair, and it's put us in this position now, and it stands to cost us potentially literally millions of dollars. So.
Jordan, if I could.
Sure.
I don't mean to, do you remember in 2017, the composition of the select board, or who was there, or?
It was Jenny's husband.
Excuse me, that's not my husband.
Oh, my apologies. I totally, somebody else had told me that, and that is, I rescind that statement. So Tim Gittich.
Yeah.
Who is this current, Tom Hall? No,
John Morris.
John Morris,
Yeah.
I'm sorry. Too many officials in my head today. John Morris, and there was one other board member. I had it printed out, but at the time, there was 3 board members.
Yep.
In both of those hearings, I was promised that we would be protected, and one of the reasons I made it a point to ask about that is all of these times that the town has erred in not issuing us that home occupancy permit. So,
Can I just ask,
yeah,
so you submitted an application for a home occupation?
I was not offered, they wouldn't even offer me the application.
Who's right? Who did you ask?
This was in 2010, so it would be whoever would have been in charge then.
Like who? Like-
Oh.
town.
The code enforcement officer at the time. So I'm sure we could look back and find out who that is.
Did you do that in writing or was it?
Oh, the request, no. I mean, I didn't receive anything in writing either. I did ask for something in writing multiple times.
You didn't ask in writing.
I did not make the request in writing, and I don't believe that's something I would be required to do in any other circumstance. If I were a business now coming to this town and I wanted to get a home occupation license, would I need to ask permission in writing for that, or could I come into the town office and ask for an application for that home occupancy? Or you're just asking for the sake of record? Yeah, sure. So, and that's at the crux of this, like, the town has not provided me anything, even though I've asked again and again and again. And it's incredibly unfair to put me in this situation. And I've spent, I've built my business. I've spent hundreds of thousands of dollars based simply on these approvals of the town that are now not being honored. And I'd like to say, to the town's credit, this 2017 promise of grandfathering has been honored until the day that Ginny has made this informal refusal of my request to have that document signed. So I implore all of you to kind of just take a moment to think about, if this were your business or your family put in this predicament, is this fair? Is this worth it to spend for us to all be here arguing over what is basically a small misunderstanding and a piece of paper? Like, it's too much. And as a citizen of this town, and as someone who's had family for 200 years in this town, it saddens me. So I'll continue with my prepared speech because most of this has deterred from that. So I'm going to touch on another piece because I know we have somebody who is a land use and zoning person here. So and I've already touched on this partially. So in your own land use ordinance on page 27 regarding non-conforming use, it mentions non-conforming use. Now, the way that Natalie Bruns said was the only way we could ever exist legally within this town is through non-conforming use. So either since we've been operating legally, clearly as demonstrated by all the documents from the Office of Cannabis Policy and otherwise, would that not fit that definition? And if it doesn't fit that definition, why did she bring that up? And why did she say that's the only way we could legally operate in this town, is if we were legally able to operate in this town at any point? She's given me this argument. And I think she does know a fair amount about land use and zoning, and I think she's right about that particular thing. I'm sure someone will refute me on this, and that's fine, because that's why we're here. So the fact is, we're still operating with local and state approval right now. Like, my business is not closed. We never received a cease and desist order, nor would it be legal to serve us with one until our current license runs out. This is, I won't speak to damages. All right, so here's the thing. I've made all these statements. People are saying things about whether we're this or whether we're that, or it's gonna fit in this box or that box. What we want is to resolve this issue. So we're hoping to resolve this issue with you here this evening And we truly hope that you are sympathetic to our situation. We just need a form signed. The town has already explicitly authorized our activities and we are grandfathered by the state. I simply do not understand why we are here other than a large misunderstanding. I may have just said that and I apologize because I'm mixing stuff from my head with this on paper speech. I'll try to stick to my speech. All right, so we just need this form signed. The town has already explicitly authorized our activities and we are grandfathered by the state. I simply do not understand why we are here other than the now quite large misunderstanding. Please, let's put this to bed. We seek to have the CEO's decision reversed and the IHS formed by a town official, as well as to enter into a consent agreement with the town for our continued operation and future protection. My counsel, Jill Cohen, has facilitated such agreements with a number of municipalities. This is, in my opinion, the best way forward. It is a simple process that will not hurt the town in any way. We believe all parties would like to stop wasting time and resources on this. This is our business. My wife, my child, my disabled father-in-law, my employees, and our patients all depend on us. Taking this away from us takes all that away. It takes my life away. It is going to be ruinous to my family, to my 6-year-old daughter. This is, and please do not take any of my frustration as being projected at any of you. This is an emotional thing for me. This is obviously a big deal. This is our livelihood. That's pretty much it, you know. I'd like to thank you guys again for being here and listening to our plight. We're confident that you're gonna make the right choice on this. And if you don't mind, I have a couple patients who'd like to come up and make testimony, if that's okay. Absolutely, yeah. I'm open to questions first, yep.
First, going back to the question. Mr. Katsakis raised. Royal, is it Royal River Town?
Sure. Yep, no, the appeal is under myself. That's just our company. So I'm an officer of the company.
You and your wife.
Correct, yeah.
And are you managing?
Yep,
You are.
yep.
And who holds the license with this?
Yeah, it's all held by an individual. Yeah, and the lab itself is under my name personally. So the appeal is my appeal.
And how did the April 21st, 2022 letter from Mr. Hill, how did that come about?
So actually, some of this is in my speech that I kind of glazed over, so I'll go back to pull the details from that. Basically, in 2022, the state began requiring a municipal approval form as part of the renewal application process. So at that point, I went down and met with Alan Hill and we discussed my needs. He came to the property, inspected everything, and then prepared that letter after that. And that's what we have used since to get approved by the state for our IHS extraction lab.
And what, have there been prior inspections of the property by a town CEO before that?
It wasn't required.
But help me understand, because I thought your position is that you were operating with municipal approval in 2018, which I think was.
By way of the grandfathering offered to us by the select board at the select board meetings.
Meeting, that was in 2017.
Correct.
Okay, and at that meeting, you made some requests from the select board.
What I did was because this was, shortly after, the state legalized adult use cannabis. So there was a lot of discussion about moratoriums and, ordinances and all of this stuff. So I went to two of these meetings, and at both meetings, I made it a point to ask about our lab specifically. And at both those meetings, I was told our lab would be protected if there was an ordinance, not an ordinance, a moratorium, not a moratorium, under any circumstances, we were to be protected. And as I said, that has been honored up until just recently. And there wasn't any inspection required back then in order for that to happen. This is a conduct, not a,
It's a use.
right.
So can you describe quickly for me what the use consists of your lab?
Sure, it's basically a shed. And it's got some extraction equipment in it. We use solvents to extract some of the components from cannabis. And then people either consume that as it is or use it to formulate something or whatever.
And are you cultivating cannabis there?
Yep. That's protected under home
Yes.
caregiver protections, yep.
So many plants per.
Correct, 500 square feet, or it's by plant count.
So cultivation and extraction. And what else?
Sales. And that's not like retail sales, like we have a store, that's like, we can sell to patients, but we can't be open to the public. We can't have a sign, we can't do anything that what a normal store would do. We're just able to serve a small number of people out of our home, like any other home occupancy
Any other
might,
healthcare?
sure.
What zone is this?
All right. Yep. Yeah, I mean, it's been proven twice, once by a permit issued in 2019 for a power upgrade for the lab, that we meet the zoning requirements, and then again by the letter issued in 2022 that we meet the zoning requirements. And then if we want to play, we don't, then we can do non-conforming use. So I'm happy to go either way. But I just feel like we've been made a promise by the town. We've done our side of everything. We don't cause any trouble here. I've never had a complaint. I don't think the town's ever had a complaint. If they've had a complaint about smell, then has nothing to do with the lab anyway. So I guess do any of you have an idea of what you think a good way forward is?
Well, we certainly hope to come to we will come to some decision, Jordan. A lot of questions in between, friend, and I've got to tell you, I'm an engineer, I'm not an attorney, but you said several times that you have explicit permission from the town,
Correct.
but I don't understand why you didn't ask or demand.
I did. I demanded multiple times something in writing and I was refused multiple times. I'm in fact very upset about it. Like,
So I've got to tell you, that's not explicit then.
explicit verbal approval is approval. I've been studying every flavor of approval, trust me.
Is your counsel here tonight?
Of course, he'd like to speak next if that's possible.
Yeah.
Thank you. I will yield to him.
Hello, Todd Ketchum on behalf of Jordan Smith. Thank you very much for having me here, folks. Couple things to piggyback on that about.
So just you're an attorney?
Yes,
With,
absolutely. Sorry, I'm in casual clothes.
Okay, with Cohen Law?
No, Jill is in another country right now. I'm standing in. I've been riding along the entire time as co-counsel with Jill
Okay,
and able to be here in her stead today.
okay.
Everything that she has filed, simply standing on the shoulders of the great work that she's done. to date. Todd Ketchum, absolutely. So to piggyback on a few things that Jordan said, and to address the threshold issues spoken about by Attorney Katsifikas, it's our position that the terse email received by the code enforcement officer is not a formal denial. That is simply, it did not cite the ordinance, relied in denying local authorization. It also did not advise Mr. Smith of his right to appeal or any such next corrective action. Such that when he came here on 4/22 to address this to the town council also did not give him a next step. He had to wait until the next meeting where he came back and said, what are my next steps? And they told him, you need to file an appeal, which was done the next day. So 5/13 told to file the appeal, 5/14 is the date of the appeal in your file. So the 30 days has not run as a threshold issue for these reasons. There still hasn't been a formal denial. There still hasn't been a formal stoppage or cease and desist or anything. So it's our position that we're all getting ahead of this and working here collaboratively. I think the goal would be, if it's not to say that the code enforcement officer has erred in this moment, there still is the ability for us to have a consent agreement that says that, be that as it may, we still can't explain away our code enforcement's letter that allowed for explicit written municipal approval prior. And we are in this pickle because we can't explain away, we can't give away that letter, you can't throw away that letter, the letter exists. All right, so we're here reconciling this history that's not neat for both sides. And we can do that. We can do that here together. There's corrective action to be able to collaboratively work on this. Because if we all know, if we punt from here at Superior Court. So, so that's the threshold issue. It does not matter if there is an ordinance in this town underneath DHHS rules at the beginning of the Maine Medical Marijuana Program, which is not under OCP where it currently is, it was under DHHS. Jordan was a registered caregiver, was providing plant medicine to patients, some of whom I do not know if patients here were being served at that time. Okay, we have patients here to be able to speak to being served at that time. When that use, when that was stopped, when that regulatory scheme was stopped, this use then we could argue became a non-conforming use because it was previously licensed, previously set with state approval, and an absence thereof in the municipality allowed us to be entirely under state control. So at that point, then it becomes non-conforming, but it exists all the way through as licensed by a state scheme. The only thing that shifted in this moment, like Jordan said before, is that we have a new form, 2022 form, right? We have the evolving of that form, and we have a new code enforcement officer. So those are the two pieces that have shifted since the last time that this was actually approved and wouldn't need to be here in front of everybody. So those are just the pieces to piggyback on. The grandfathering timeline, as a caregiver operation with a local authorization. Let's see. Must have printed it a little too small for my old eyes, my apologies. But I just want to bring us back to the letter issued by Allen Hill is unambiguous. It's not been rescinded. It's not been disputed. It's not been retracted by the town. And the state of Maine has accepted this letter as proof of local authorization more than once. And you had questions, please.
I have a couple questions. While Mr. Smith was licensed by DHHS, what was, if anything, the scope of Allen's home rule authority with respect to that?
I may bring Jordan back up to defer on that. He was student.
Still falls under home caregiver protection.
So the scope of initial caregiver protections were that someone operating a small size caregiver home operation would involve themselves in small scale sales direct to patient. Also, sales are permitted to other caregivers, all their licensed caregivers, right? And that they would be able to use either IHS extraction or non-IHS extraction for their home business. That was in the scope of the initial purview of DHHS's rules for home caregivers.
No municipality have zoning regulation about Portland.
They can absolutely choose to have an ordinance, but that this town did not, right? An ordinance saying that they won't that they won't allow DHHS medical licensed caregivers to operate, and then it would have gone to court. So that, they could have done it, but it was not done simply because it was in conflict with state law.
That regime, it was permitted use unless municipality acted.
No, please speak for me. I didn't operate Jordan's business at the time.
Even by court. Because state law supersedes municipal law.
Excuse me, could anyone that's speaking in the audience please move up to the microphone
Do we want to?
for recording purposes? Thank you.
No, thanks very much. Yeah. Pardon my, yeah, pardon me.
So any town in Maine, if you are a home-based caregiver, you have these protections and you have confidentiality protections. So for instance, right now in the state of Pownell, you could call OCP and you could ask them, can you tell me if so-and-so is a caregiver at this address? And they would say, we can't tell you that. And that's been the way it's been forever. And anyone that's still stayed inside of that box, that's still the case. So you don't know who any of the caregivers are in your town, except for the ones who come down here like me and are like, hi, I'm doing this in your town. I would like to do everything I can to do this correctly and in such a way that is not gonna cause any conflict. And then the only thing that happened was eventually there became a requirement for municipal approval for the IHS manufacturing, for manufacturing of edible goods and anything else?
IHS manufactured edible applications.
And a caregiver retail store. Those are all things you need municipal approval. So we've been given municipal approval for this lab. And we've demonstrated that we have 14 years of history operating it. We've demonstrated how non-conforming use could easily apply to this. And then also page 40 subsection G of your zoning ordinance also specifies any DHHS licensed health facility fits within that RA zoning. So the second that went from DHHS to another governing body, that also makes us a non-conforming use and protects us. So there's a lot of different angles we can come from. We don't want to we don't want to talk about any of that stuff. Like, we want to reach a reasonable agreement with other residents in our town that benefits everyone. And that's all we want. And that's all we've wanted from day one. And it's all I wanted, it's all I've ever wanted from since I moved here, to just be treated fairly. And I think that's all anyone ever wants from anyone. I yield.
I would like to strike my misstatement, like I said prior to Jordan's correction.
So the statute doesn't read the way, it doesn't say that you have to operate this approval.
So that municipal approval was provided. It was provided in an oral way. It was provided in this. Sure, yeah, but I thought there was a question mark on that.
That is not the statute says you have to operate with these.
December 2018, which was withheld, but not, because it was given to Jordan prior and after. Okay. That's what you're stating here without, without a review of the controlling statute in question. I'm not gonna be able to provide that for you.
Assume I'm correct. Says,
If you like.
why would, what would be the municipal approval one would get if it's correct that no municipality had any power to approve of these uses under the DHHS regime?
I think you're reading it negatively, so it's not approved of uses, it's just, it's prohibit the uses, right? So approval wasn't necessary. Approval just became necessary when forms changed to require that.
And that was under OCP, not the.
Right, that's a different regulatory scheme.
When did it change from DHHS to OCP?
Late 2018 or 2019?
It's right around that timeline that it's right around the end of that year. I mean,
So they enacted the statute and said, well, grandfather, you are operating this approval under the DHHS. That fairly.
Well, that's what it says.
well, DHHS had, yeah, right, because DHHS had yielded their purview to MMMP at that point. They created their own department. This has been an evolving process and the most successful medical program in the country.
What I'm really just trying to is what is the municipal approval that one would have to show?
The signed,
under that
the signed,
Oh, I can answer
you,
that.
please feel free. We have plenty of it. There have been municipal, I mean, there have been state approvals throughout, all the way down. And then he has some more to supplement the record here. Go ahead. I understand what you're saying, but we're in a situation that we're trying to, in this discussion, iron out the challenges of this exact distinction between state and municipal law when we're dealing with an issue like this, right? That you haven't decided to have an ordinance. There's been an existing use. By all terms, this has been an approved existing use, but we're trying to see what that means when it's been a patchwork from the town's perspective that we've seen. So, I mean, we're here to resolve that. We can certainly stitch it together, make a quilt. But this is now that I've delayed, you could dispense.
All right, I mean, again. Can we stop here and maybe take a moment and see like let's take a temperature here, like who feels like we are gonna be able to reach an agreement that's gonna work for everyone?
Jordan, we
Right
don't know
now.
that yet. We don't know that.
Okay, I'm just trying to, yeah, I'm taking the temperature.
Right.
Absolutely.
Right,
Yep.
so what we're trying to do is go through what
Sure.
see what the path is.
So,
say that-
yeah.
And you can walk us through.
Some of you may not know this. Have been working in cannabis politics for 14 years as well. I actually helped author the bill that we're talking about this evening, and I can tell you that, this wasn't the interpretation of the bill. Okay, so state level, just a short thing I prepared that I wasn't gonna use, but now it's become relevant. A Harvard graduate and current member of the state Senate shares in my opinion of this statute, but others do not, as with every law. I spoke with him on March 27th, 2024 at 6:41 PM on this matter. I would like to mention this is one of the top minds in cannabis policy in the state. I will withhold his name from public record out of respect. I have in fact spoke with several colleagues in the House and Senate to seek advice on this situation and to seek a legislative solution to this being a problem for others in the future. So this is the interpretation and why grandfathering can work and legally works without the language outlined by OCP, because that's only one interpretation of the law. You have to understand that OCP is given statute. They're allowed to make these forms and they're allowed to make these rules and make these other things, but everything goes back to the statute. And every statute has three major components. I don't know why I had to look at this. So, okay. You've got intent. When you're writing a bill, you have the intention that you're trying to achieve with the bill, correct? Nobody's gonna dispute that. Then you've got the language or the statute of that bill. That is what it is. The person that wrote it may not understand the intent of the bill. It may be a paralegal that's working for them. It may be whatever. It's more subjective than you think it is. And law is more subjective than you think it is. So the third part, and the most important part, is interpretation. So I'm going to give you this interpretation from these incredibly brilliant people who I work with regularly on writing these laws and on changing the laws that are written poorly. So if a business was engaged in extraction, now called IHS extraction, all that was required for, and this is going to be redundant a little bit, all that was required for several years was a caregiver card. If that caregiver had a card, then the only other permit needed would be a home occupancy permit, and that would only be if they were the homeowner. And they would already have it because they're living in the house and need to be there, obviously. Which they would already have unless the primary structure had not been completed. We're gonna assume that's not the case. Since it is a home-based business, ergo manufacturing facilities were part of home-based caregivers' conduct until very recently. The town has always supported our operations despite poor record keeping, which is causing problems now. The last part of that spoke to my personal situation, but the beginning speaks again to how this works, is because you can be grandfathered far beyond before grandfathering even happens. Because you have every document necessary to do that conduct legally. Does that?
So to answer your question, the caregiver card would have been all of the approval necessary for him to have these operations that were inherent in a home-based business.
Up
At that
until
time.
the municipal approval was required.
So why would there be a reference to municipal authorization prior to December of 2018 at all?
Because there's a patchwork of state regulations. Every municipality was handling it differently, especially because that was an inspector of adult use
And it,
coming in everywhere.
It
So that's
also
really the
doesn't
ordinances
matter-
were widespread in response to adult use more so than caregiver. than
like,
caregiver.
if,
But this statute is specific to the medical. One that we're talking about.
which part?
The one that says that a municipality can't
Oh, correct, yes.
stop you.
Yep.
If you were operating with municipal authorization as of December 2018.
Yep.
And yes, I'm just not completely understanding the argument. Maybe I'm just, I think my fault, but help me. Are you saying that you had municipal authorization the way that statute is talking about in December of 2018? If so,
Mhm.
how, what was, who authorized
The select board.
in 2017?
Correct. And my wife and I have both submitted sworn affidavit, and I can come up with several more witnesses that will attest to that. And that will certainly hold weight.
Anything, is there anything else, or is that the authorization that you had in December 2018?
Municipal inspections for buildings, property, use of the property. Prior to.
I'd have to look through our
Yeah,
records.
so prior to 18, that would be something I'm just thinking
And
about.
it's
in the moment of
also
like,
not something that's necessary.
yeah, but that electrical use is gonna be
None of
for a
that's
caregiver. That's not like a
necessary.
residential home use. That's like commercial use.
Statute's pretty clear that the authorization must be specific.
And if y'all weren't handing them out, this is very convenient, you know? So it's great to say, well, they said yes before and they said no before, and now we're saying no because they've said yes and no, which is, it's an answer.
Yeah, we're trying to not, we're trying to put all this aside because it actually doesn't matter if you look at, is this two-sided?
No, it's fine. But you can,
There's provisions within this document as a workaround through a warrant article or otherwise for a fix for this. There's also two provisions within your own zoning ordinances that also are ways that this could be dealt with. So like for us to be getting hung up on all of these other parts and these minor technicalities and ignoring everything that's at stake for me and my family is, it's not human. I understand the process. We've respected the process. We've gone through every step of this. I've been defamed by the town attorney who accused me of operating illegally throughout the entire time we've been here since 2010. I don't take that lightly. I grew up being ostracized for cannabis, and to have somebody say something like that, it's a line for me.
Jordan,
So,
we're determined to give you a fair hearing, that
yeah.
that
I
this is done
understand that. I'm just
honestly.
hearing
straightforward.
some,
But we also have to answer to the people of Pownell. We have to
Sure.
answer to ourselves. We're all volunteers. We want to make sure this is
Yep.
done right.
okay.
The zoning board of appeals does have counsel here tonight. Jim, would you like to introduce yourself?
here, quickly, what are the two ways, you said there are two ways under our to get to the finish, what are?
Pardon me?
So,
You said there are
if-
two ways
right,
under
so
the zoning ordinance.
there's,
Yeah.
there are two ways that are not relying on this grandfathering
We have
piece.
three different things on the table, plus.
Jordan, come to the microphone.
Yeah, we have three different things based on our own interpretation between both of my attorneys and myself of the grandfathering clause. And our expectation that the town is gonna honor that grandfathering promise that they gave us.
What are those? What are
And
those-
then the second, so.
What are those three
two things are, again, as early in the program, there were only two things. There were home-based caregivers and there were dispensaries. There is no limit on home-based caregivers, and the home conduct of a home-based caregiver included cultivation, extraction, and sales. And manufacturing of edibles, but I believe at one point you were required to have a commercial kitchen to do the edibles. So,
And no town could regulate where those activities took place.
correct.
That's right.
I know it's hard, I know it's like a. tough thing
Yeah,
to
so
swallow, but
what state law said, what state law said that? that no town-
Law.
Well, that's not helpful, sir.
I'm sorry, I just
I'm
don't.
happy to brief you, to provide a brief of that for you after the fact, if you'd like.
It would- it would-
Yeah, you could
Absolutely.
find
It's
it would be good
the
to know.
promulgating statutes of the main medical program is what we're talking about. Yeah,
said no town can regulate the
absolutely.
location of
Yes,
these activities.
100%.
Okay.
Yeah.
And I'm
So
happy
you
to
can't-
provide this after the fact.
That would be very helpful.
Control can't be used to stop a caregiver.
Home-based.
Um,
Home-based.
if they're, in egregious violation of some code that is unrelated, you could do something about that, but
There were-
that's not.
There were prohibitive pieces, but not for this.
But not regulating the use.
Yeah, not regulating this
Right.
particular use fits squarely under.
Okay, what's the third thing, or the second of the
The second.
two that aren't grandfathering?
There you go. So talking about the zone, these are the two zoning pieces that allow, because this
Oh,
was.
So since this was a DHHS, a licensed DHHS facility. And then became no longer, excuse me. I'm gonna word this exactly
Authorized.
as in the ordinance. A healthcare facility licensed by DHHS. So what happens with that? That meets our RA zoning to be qualified as that, all we need is also the caregiver card. Because that, by providing medical care and being licensed by DHHS, we fall under that definition within that zoning ordinance. So when that transitioned from control of Department of Health and Human Services to OCP, that automatically put the use and conduct into the definition of non-conforming use.
Because when that DHHS licensor regime stopped,
Right, then we're no longer.
now municipalities were able to regulate the,
No.
That's okay.
Well, how did they-
It wasn't seamless like that.
how did the use
It
become
was-
I can see how, I can understand why you're going that way. Go ahead.
So that's, a lot of these are, these are new laws and they're complicated and there's a lot of contradictions and they're very long. And I can tell you as someone who works very closely on a lot of these pieces of legislation, we're really working on tightening up the language because of confusion that's caused by it. So, these are the two ways that I'm offering as avenues to grandfathering outside of that, the one that that OCP outlines as their interpretation of the requirements for that. So yeah, those are, if you have a caregiver card and that town you are in defers to state law, that caregiver card constitutes being fully permitted and approved of that conduct, and that card is that approval.
and the town doesn't have to do anything affirmative to defer to state law, as you're saying. If it does nothing, it is by definition deferring to state law.
Right, and the state has an inspection regime where they come and they inspect the facility and they make sure that it's safe, make sure that he's doing everything above board, which they've done, and we have record of that.
And I think, was that provided to you, our recent OCP inspection from 3/26?
We have that to supplement if you'd like.
Yeah, okay.
You got it with?
I haven't seen it.
I don't remember having seen that.
Jordan,
Oh, well, that's incredibly relevant. Becky, do you have that?
No, I didn't.
Do you mind? It was in the packet I
Oh, the
provided.
one
to you.
today,
Yep.
it's right up there.
Go ahead. Yeah,
Certainly.
so yeah, these are the two signed affidavits.
Yes.
Regarding,
Yep.
2017. These documents, I'm gonna explain what each of these are, and then I'm gonna hand them around. So, page one this is all our caregiver inspection of these first few pages, done on Wednesday, April 3rd, 2024, so I'm just gonna do some highlights. Okay, check activities that apply, cultivation, manufacturing, patient, sales. On-site cultivation, manufacturing. Manufacturing, yes. Local authorization required for manufacturer, Title 22, 249, Title 22, 2429-D, unless operating prior. I don't know why it doesn't say two, but unless operating prior 12/13/2018. Extraction, yes. Extraction IHS flash point at or below 38 degrees Celsius, 100 degrees Fahrenheit, yes. Extraction IHS types, butane. Review of engineer approved extraction plans, mandatory for IHS extraction, compliance.
So Jordan, those support your argument in that you have official paperwork from the state that says you can conduct yourself in that capacity.
we were just approved with this and found 100% compliant. So what that demonstrates is that we, despite what the CEO and Natalie Burns had claimed as far as us it being illegal for us to operate within this municipality, this is evidence very much to the contrary of that.
I don't doubt you, but,
so
we're just,
anyway.
yep. Cliff, do you want to see any of this portion that Jordan could?
How often do you apply for relicensure or re-upping your
Once a
license?
year.
Once a year?
Yep.
So in 2022, you did, and you got this letter, right? What did you do for 2023?
Who's that?
Use this letter again?
Yep.
Okay.
Do we have a caregiver card on file for
I
your?
have a picture in here. And then you probably don't need, you've probably seen this application form 1,000 times, so I'm gonna take you right out of here. And then that's on, the card's on the last page. I just redacted the center of it, I'll show you.
One we have here?
Uh,
Oh, this is from a different package, Dave.
Oh, okay.
It dropped off today. so-
All right. So you've seen it.
Yes.
I just saw it
The
a
only
while
thing I dropped off previous to this was kind of like some of our patient stories, which I hope were impactful for you because that's kind of the heart of why we started this and here I'll start. To you. Basically, this just, it confirms that we have all the things we're supposed to have
Understood.
despite what's being said otherwise.
I'd like to hear from our council.
Did you apply for licensure in 2024?
Not yet.
Not yet.
And we're trying to get this done before that,
Why not just use this April 22 letter again?
because they changed the form and that's the problem. They require, sign will require this very.
Okay.
The word.
All right.
Jim, if you would introduce yourself.
Again, Jim Katsifikis from Perkins Thompson, representing the board, advising the board this evening. Not taking sides. I'm just trying to provide some information to help you as you try to make a decision. There was a question that Mr. Ruprecht had asked, and that's with regard to how the statute currently is. And just to verify, under section 2429D, this is pursuant to home rule authority granted under the Constitution of Maine. A municipality may regulate registered caregivers, caregiver retail stores operating pursuant to 2423A, registered dispensaries, cannabis testing facilities, and manufacturing facilities. A municipality may not prohibit or limit the number of registered caregivers. And I think relevant to this is subsection 2 and 3. A municipality may not prohibit caregiver retail stores, registered dispensaries, cannabis testing facilities, and manufacturing facilities that are operating with municipal approval in the municipality prior to the effective date of this section. The effective date is December 13, 2018, as has been mentioned. For purposes of this subsection, municipal approval means an examination and approval of the store, dispensary, or facility for the use of the premises consistent with conduct authorized under this chapter, including but not limited to a conditional use approval or site plan approval. Municipal approval does not include issuance of a building, electrical, or other similar permit or authorization that does not address the use of the structure or facility for which the permit or authorization is issued. I believe you were discussing that piece. With regard to the third one, municipal authorization needed, a municipality may not authorize caregiver retail stores, registered dispensaries, cannabis testing facilities, and manufacturing facilities that are not operating on the effective date of this section to operate in the municipality unless the municipal legislative body, which would be the town meeting in this town, has voted to adopt or amend an ordinance or approve a warrant article allowing caregiver stores, registered dispensaries. So that's where that comes into effect. We're looking at December 13, 2018. We have, I think you've received a letter from the prior code enforcement officer dated 2022. So what was going on is of 2018. And then finally, there's a little bit of confusion here because when this board's talking non-conforming uses, you're usually talking about non-conforming uses under your zoning ordinance, not non-conforming uses otherwise. There is a use that is permitted right now today in the RA, and that is for health facilities, but it's a conditional use. So you'd have to go see the planning board and get your conditional use approval.
Right.
And a health facility has a specific definition under your code. And that definition of health facility, I mean, I had it a moment ago.
Department of Health and Human Services.
Well, not only licensed by Department of Human Services, not Health and Human Services, so it's an old definition, to provide lodging, food, and medical and nursing services to residents requiring supervised care. So, you know, leave it to you as to whether this would fit under that sort of definition. What may be at issue here is initially caregivers were allowed to be operating throughout the state without municipal approval. And that was under the initial law. What did that include? I think Natalie Burns is, I'm not making the arguments, I'm just reciting what was written. I believe what Natalie Burns was saying is that at that time, to offer more than caregiver care, to do the manufacturing, there had to be an ordinance that authorized it, and there was no such ordinance in the town. There has not been any ordinance in the town. And so if there had been, then that could be lawfully non-conforming under state law, not under your zoning ordinance. And that's why this is so tricky and why this is a question of jurisdiction in a sense, because we keep talking about nonconformities and uses under state law rather than under your ordinance. But at any rate, that's what the statute provided. It may be helpful to go take a look at what the statute provided initially and get more information as to what was or was not approved. But the question is, was there municipal approval? They're talking about as example, site plan approval, conditional use approval. Those would be a written approval. There would be something from the planning board that would serve to help you understand what was and wasn't approved and when. So that's the status of the law on that. I'd be happy to try to answer any questions.
One quick question.
Yes, sir.
Is this, is what you're saying there, is that why the selectmen didn't give him anything more than an oral agreement? They didn't feel like they even had,
We weren't there.
I'm just trying to
No, I
understand why
understand.
they refused to put anything down in writing.
Well, I think what's been said is that this is a state matter.
All right.
I think that's what's been indicated in the writings that we've seen in the file. So I'm not, I'm not testifying, but that was in the appellant's letters. And this is a state matter. And you got your caregiver card and it's whatever it is.
I heard from the HHS was licensing caregivers, that unless.
Back when DHHS was licensing caregivers, unless a town acted affirmatively to prohibit them, they were authorized. Can you shed any light on that?
Well, there was an opt-in where municipalities could opt in to allow some of these other uses by adopting an ordinance
For medical?
for medical other than caregiver, as I understand it.
Other than caregivers, okay.
Right. And so then the question becomes, what was the scope of a caregiver license? I don't have that answer. And that's something we should probably take a look at.
So it may be that as a caregiver, he was permitted to do certain things, but not everything that he's trying to do today.
I think that's the town's argument, the code officer's argument.
Thank you, Jim.
Approach again, please.
Hold on just a little bit, Jordan, if you would. John, do you have any recollection, John Morris, first selectman, do you have any recollection of a meeting in 2017?
So, John Morris, Durham Road, Pownell. So the conversation in question was happening during a public hearing where we were discussing whether or not the town was gonna opt in for to allow marijuana businesses in town, so it was commercial. At that time, Mr. Smith was there, and he came forward and said, well, I'm already operating. Well, that was because medical marijuana caregivers are anonymous and are closed to the town scrutiny. That would be the first that I heard. His question, as a medical marijuana caregiver, is he grandfathered? That was a moot point because we had no authority. We had no jurisdiction. We didn't even know he existed. So I think the answer was, well, we really don't have, we can't prohibit you because you're a state and not a state function and not a town function. So I think the issue, from the select board perspective is we had no authority to approve or disapprove of Mr. Smith's operation. We had no dog in the fight since that was not our jurisdiction. Okay. Is there any other question while I'm up? It's a long way up.
You're confirming what I just said then.
Thank you, John. Jordan, if you say you want a few more minutes, then we want to move this along.
Well, yeah, I'll certainly say that's not how I recall the meeting, and that's not how my wife recalls the meeting. And you'll see in our sworn affidavits that we've provided that is not our recollection. I don't dispute the language of the grandfathering clause, which is why I've been trying to point out to you that every law has multiple interpretations. That's the written interpretation of that law. If we want to go by that, we're wrong. If you want to honor your promise to me as a citizen, as this town, and not put me out of business and put my family out of house and home, then the right thing to do is recognize the grandfathering that was bestowed on me in 2017 at those meetings. And then if that's not possible, then we should reach an operating agreement outside of all of this. Because if we reach an operating agreement, none of this matters. If we reach an operating agreement, it doesn't matter. We started operating, and increasing costs for everyone. I just think I'd really like to, I'd like everyone to agree tonight that we can come to some sort of agreement, in disregard of all this information, because we've got 50 more things we can argue. We don't want to do that. He does too. Look at all the stuff he has. Like, why are we here? Why has it come to this? And then furthermore, this is really my last offer at this. Like, I've tried so hard I've been through so much. I've been through weeks. Look at this, my watch, that doesn't fit me. I haven't been able to eat. I haven't been able to work. Like this is a big thing for me. This is my whole life. So if I don't get some assurance this evening that we are at least going to work towards a solution to this problem, we will explore other options to get what we need. And I don't this isn't a threat in any way. I need to provide for my family.
I
That's it.
assure you, Jordan, we want to do this in a fair and honest manner.
I appreciate that.
Do you have any other parties? I know you had some,
Further,
yep.
I would like to have a couple patients come make statements, please.
We're going to address that. We're going to move on now. Parties to the action have stated their case. We'll now take testimony from interested parties. I'd ask folks to, if they'd like to come up and make a short statement of some sort.
Sure. Sam?
Jordan, thanks. Yeah.
I'll let you call him from now.
Good evening. Thanks for letting me speak tonight. I appreciate that very much. My name is Samantha Frederick. I'm a patient of over a decade for Jordan and Jill Smith. They have provided me with cannabis support as I'm a patient that has epilepsy. You may have seen when I was here earlier, I had a little baby with me. My son, he's now taking a nap in the car with his father. But because of my medical condition and having pursued traditional pharmaceutical methods of treatment, I was unfortunately a person who lost their driver's license. And you have to be 5 years seizure-free in order to operate a motor vehicle safely in the state of Maine. You have to have a doctor sign off on your ability to do so. I also lost my job. I worked as a social worker. I worked for Department of Health and Human Services and Child Protective Services. I also worked at rape crisis centers, domestic violence centers. So my background was in helping people. I lost my ability to do that, and it was, to be honest, extremely depressing. I lost my social life because of that. You can imagine if you're a person who cannot work, cannot drive, cannot conduct a normal social life, that starts to take its toll on you as an individual. At that time, I had gone to Brigham and Women's Hospital in Boston. My parents had paid for extensive medical care and I wasn't working. So I applied for Social Security disability because I wasn't able to provide for myself at that time. I was an adult, 30 years old, and that's frankly kind of difficult and embarrassing. So I had taken a variety of prescribed medications from my doctor. None of them worked. The seizures were in what they call intractable. I had a lot of side effects from those medications, which were very difficult to deal with. And I was just lucky to, in my capacity of having known people in the social work field, to know that there was a presentation on medical cannabis and the treatment of seizures that happened at a coworker's workplace. And so at that time, it was the first time I had heard any medical research, scientific-based information on this topic. I'm not a person who previous to that had recreational use. So for me, this was something that I was trying as a last resort, to be honest. And at that point, I was introduced to the Smith family because they had a caregiver card, as you heard Jordan talk about in the early part of that provision. And I provided a written statement as well that Jordan has turned in to kind of give you all these facts written down.
Okay.
And at that point, I was very happy to see they were a family business. So you can imagine as somebody who's not, never approached this on a street level, shall we say, that a person that also has to be background checked for their employment, going to a family home where you can see these lovely people and their child are present, and I didn't have to meet somebody in a strange parking lot. At this point, there are no medical dispensaries, no stores, if you will, that I could go to. There is also not a ton of people who have the scientific mind or the intellect in that capacity to present what kind of medication might actually treat the symptoms I was having. Having tremors and grand mal seizures is something that had interfered with my life tremendously at that point. And so Jordan was able to present me because I was quite nervous about pursuing this path with research from other countries, because as you may be aware, the United States does not have federal research at this point. They're still trying to develop that. So he was able to present me with information from the United Kingdom and from several other countries that were showing the treatment with CBD or cannabinol for seizures. And at that point, he asked me if I would like to trial that to see if that helped me. And I was willing to do that because I had exhausted all my traditional avenues, if you will. And it's also something that's not psychoactive. And so that for me and in my ability to hopefully regain work was important. He was able to help me dialed in a specific dosage that was able to stop my grand mal seizures. And that's something I've been now at this point, almost 9 years without a seizure. And that's specifically because of the medication that Jordan provided to me. And I will also mention that he provided this at no cost for over a decade. So it is something that he is compassionate about and he is driven by a purpose. Although he is running a business and needs to support his family, he's chosen to take on pro bono work, if you will. I never asked him for this. It was something I expected to pay for. And it was a wonderful gift that he gave to me and my family. And because of the cessation of seizures, I'm now able to pursue work, been employed for several years. I have my driver's license back again. I've just recently entered a master's program for clinical mental health counseling, so I'll become a therapist is my end goal. I'm getting a 4.0 in that program. I also have my beautiful son because I was able to be healthy enough to sustain a pregnancy. So I know that when people hear cannabis, there's a lot of negative energy that may come up for people, but it has more nuance and more depth to it than that. And I'd like people to consider the human side, as Jordan brought up. And you could tell when I started talking, I was a little bit nervous, to be fair. And that's because he's a person and these are family that I care about. So I do have investment because over a decade of providing care to me, when I couldn't drive, he drove and brought me my medication. When I lost my job, he brought me this bag with a nice like t-shirt and flowers and was like, it's okay, like you'll get back, don't worry about it. So he's a person in addition to a businessman, and you're having someone come to you and, as you mentioned, name themselves. He was unknown previously, stepped up and addressed with the town that he was in business in this way, and then has proceeded to attempt to the best of his ability, not being an attorney, to meet all these stipulations and statutes. And if you have looked into cannabis in the state of Maine, the Office of Cannabis Policy has many towns where issues like this have come up because it's not black and white. And I can tell he's very passionate and very moved by what's going on because it does affect his family's livelihood. So considering that there are a lot of people who are positively impacted by his business, and additionally, hopefully your town is positively supported by the fact that that business is generating income for your township. That's something to be considered. What would you gain if you were to close a business and what would you lose? And I can tell you, I would have a lot to lose. So thank you for your time this evening. I appreciate it.
Thank you very much. Andy, did you want to say something? I thought you were getting up before. You all set? Is there anyone else who'd like to make, Becky?
Hi, Becky Taylor, Chase Town Administrator. So just two brief points. The Thursday after the March 19th email, Mr. Smith called me in hopes that I could come to some sort of recollection for this. He had mentioned in that conversation first meetings in 2018 in front of the select board, then 2017. Later that day in March, I went through all the minutes and I didn't see his name or that conversation appear in the minutes. Today, he came in with that affidavit stating 2017. So I did go back through all the minutes of the select board meetings in 2017. And again, I didn't find his name or that conversation giving him authorization captured in the minutes. So I just wanted to make that point. The second point in regards to the 30 days that appeal is usually filed on April 3rd, me and Mr. Smith had an email exchange. He asked me if the select board could overturn a CEO's decision. I said they could not. His next response was, then let's get an appeal filed. So I gave him the instructions. He said he was going to do that. The next day in the email, which you all got copies of these emails, he stated that he misspoke and he wanted to be placed on the agenda for the next select board meeting. So I just wanted to clarify that that happened on April 3rd, which was within the 30 days to file the appeal. So he was instructed at that point, or a discussion at least happened in that point about an appeal in 30 days.
Thank you, Becky. Is there anyone else who would like to say anything for or against?
Good evening. My name's David Stevenson. Jordan's my brother-in-law. I'm also a cannabis caregiver in Maine, have been since 2011. We work a lot together. He does all my extraction work for me. And yeah, it would hurt my business if he were to have to shut his doors. You know, and also I think that there's like an easy solution here. I don't really understand what the problem is to begin with, right? He's been operating for 10, 12 years now without any issues. All you guys need to do is come up with an ordinance that you have full control over and could limit one party as with an extraction lab. So I understand you might not want more extraction labs, but this guy's doing a good job and he's doing it by the book. He's paying his taxes. He's honest. He's a good guy. You know, he has a beautiful family. We want to support him. I think he's not doing anything wrong, right? And he has had, it's been a very gray area with the town. From what I understand, there was oral permission given, and I understand that the laws are constantly evolving and changing. All that set aside, it's very simple to come up with an ordinance. And you guys can also, I mean, I hate to say it, but you could charge a fee as well, as most towns do. So there is some financial gain there, at least to cover your costs, you know? It just seems like that's an easy solution to this problem. If you don't want more extraction labs in town, that's fine. It's an easy ordinance to write.
We don't have the authority to write up new ordinances. That can only come through the town meeting and stuff. Our obligation is to address the ordinances that already exist.
I understand.
Yep, we will come to a decision.
Okay.
Yeah.
Thanks.
Anyone else? Yes, Andy?
Andy O'Brien, Selectman. I think it would only be fair if you hear from the code enforcement officer.
Jenny, would you like to?
Sure. So when Mr. Jordan came in and presented me with this form, the first thing that I was sitting in the office and I told him that I didn't shoot from the hip and that I would take some time and look at everything. I didn't see anything in his personal property file except for 2 electrical notes. The letter he gave me from Alan Bell was not in that file. I didn't find anything for home occupations, but I didn't find anything in the ordinances that stated anything about cannabis ordinances, and I didn't find anything in our business listings. When someone's in business, they come in and fill out a form and stuff and add it in a notebook. I had nothing that stated that he existed, not even a little note. And so from there, after reading this form, I had no proof really that he was grandfathered, how he wanted it to be. And when I looked at Alan's letter, what it said to me when I read it, just for my own interpretation, was is grandfathered for the following activities: cultivation of medical cannabis. It didn't say anything about being grandfathered for the lab. And so when I looked up definitions of cultivation, I looked up in the state of Maine, and I'm not even sure if this is one of them, and it's under Title 28G, and this is under the adult use cannabis, okay? And sometimes I'm not sure whether Jordan's operating out of both or just one side. But I looked it up, and I also looked it up in a regular dictionary. And it says cultivation or cultivate means the planting, propagation, growing, harvesting, drying, curing, grading, trimming, or other processing of cannabis for the use or sale. Cultivation or cultivate in this particular instance does not include manufacturing, testing, or cannabis extraction. And that came from. So I had that definition to go by, is what I used, plus, like I said, I did look it up in the dictionary, and it did say the same things about propagating and cultivating in that sense. I couldn't sign the form for the town, because we know I have no solid evidence, and that's just not something I can do. I can't do variances, I can't do, I can't call it a non-conforming use. That has to do with higher up beyond me. I have no vote here. All I have is what I did, and I could not see that I could sign this form for Mr. Jordan due to the fact of the language and the fact that I just did not have solid enough information to say, yes, he's been in existence.
Thank you, Jenny.
Well,
Anything, sir? Real quickly, please.
Bill Schmidt, Polar Range Road. Ginny always does a fantastic job, as you know, very thorough, all details. When it comes to some of the paperwork, I don't think you find my building permits in there from Alan. He was a fantastic guy, but some of the stuff is kind of limited. It looks like, as John confirmed, the board was aware of his business. And at least, Alan appeared to be aware of this business, and probably a lot of other people aware of the business. You know, I don't have anything to do with marijuana. I have a security clearance, so I can't touch it. But, I think we have to kind of, you know, I certainly support it over a lot of the other chemicals that we're putting in our body, but that's neither here nor there. But I'd like us to think about his past history.
Thanks
Thank
very
you.
much. Thank you. Thank you. Anyone else? If not, then, going to close this hearing. Oh, is there one more? Yep.
Sorry if I'm a little bit nervous, but last time I got up and did public speaking, was at my mother's funeral. I've been living in Pownell since 2008. This is my mother's house. She was a Hall related to the Vollsmiths. Craig Vollsmith, everybody knows him. I'm a descendant. So I've been there since 2008. My son was very young and he had what's called feverible seizures. And he had grand mal seizures, which as a father and a parent, that's very concerning. My neighbor at the time, across the street directly, was good friends with Jordan. And he introduced me to him, and, you know, cannabis was a new thing. I was skeptical of it and that. And, he provided me with a tincture that I gave to my son, 1 to 2 drops underneath his tongue, you know, daily. Since that year, he's never had a seizure since. I prescribed him Depazan, which is a shot cream, if you will, and it sedates them for sometimes 2 to 3 days after. Cannabis didn't have that effect. Fast forward, Jordan has lived around here as far as I've known him since 2008. Always kept to himself. I didn't even know what he did. He kept his, you know, business above board, legal, been by the book, which, you know, is very hard for a lot of people to do in that business because there's a lot of criticism to it. Best friend of mine owned an operation as a caregiver in Topsom, and it makes it very hard to keep up with the regulations and the changing laws, but they do it. And I think everybody should pat Jordan on the back for being here and being above board and bringing it to your attention, and hopefully in the future going forward, that this can get cleared up to make it easier for newcomers or even Jordan to keep going with his small business that he has. Most recently, I went to Jordan because my mother had cancer. Only 500 people in the country had the type of cancer she had. Jordan donated me enough product, but I wouldn't dare to guess was a net value of how much money, but he invited me to his house after one text message and he donated it to me for my mother. My mother was 61 years old, I believe it was, and she looked down on cannabis like a lot of the older generation do. Don't take offense. It's just how it is. It's misinformation. She was prescribed many different things by her doctor. Cannabis and CBD oil was one of the very few things that gave her comfort. The only dislike about it was the smell, but she got over that. It was working. Up until she passed, she used it as a lotion on her stomach, and that's where the cancer was. And it gave her comfort. The doctors wanted to give her morphine. She passed it up. She wanted that. So Jordan does very thorough work. Everything he does is lab tested through, you know, the state, all the hoops. He's subject to walk-ins and whatever from DHS, so everything's very thorough. As far as the cleanliness of it and all that, everything's lab tested. So I know people hear chemicals, they're like, oh, geez, there's chemicals in it. Well, it's tested for not having that, not having funguses, bacteria and all that, especially for cancer patients. That's, you know, it's gotta be really clean for them. So I think Jordan does a stand-up job, and I think he's, you know, admirable being here, standing in front of you, putting himself out there and saying, here I am, because there is a lot of growers out there that do not do that. So I hope you guys can get it cleared up and make changes for people in the future to have a future at this. So, thank you, guys.
Thank you very much. My condolences on your mother. Yes, John.
clear that the sort of the crux of the position of the town is found on the form, the state form that our CEO couldn't sign on section 3. Ginny, could you read that?
Section 3, local authorization of IHS manufacturing facility within municipalities. This section to be completed by the municipality in receipt of request for approval of local authorization. Section 3A, request for approval of local authorization to operate a registered IHS manufacturing facility in municipality prohibited unless authorized by municipal ordinance or warrant article, or unless in operation with municipal approval prior to December 13th, 2018. A person or entity operating a medical IHS manufacturing facility within a municipality may not request approval of local authorization to operate the medical IHS manufacturing facility, and a municipality may not accept as complete the person's request for approval of local authorization unless the municipality permits by ordinance or warrant article the operation of registered IHS manufacturing facilities within the municipality, or unless the IHS manufacturing facility was operating with municipal approval in the municipality prior to December 13th, 2018.
Thank you, John.
Can I ask a quick question of Mr. Katsiakis? Mr. Smith's attorney mentioned that nothing in the CEO's email said this is the final decision of the CEO or notified him of the timing of an appeal. Is that required? The ordinances notify the public of the timing for appeals. Is there a requirement that for the action to be final and appealable, it has to say so in so many words?
If you were sending a notice of violation, you'd have to recite the section that's been violated and explain that the person has so much time to appeal and that you could be fined. That's if it's a notice of violation in order for it to stand. If it's simply a denial, denial does not have to have all of those other requirements. It just, you've made a request. I find it's not allowed under the ordinances. That's the decision of the code officer, and that's appealable without anything additional.
Okay, thank you.
Yeah.
Real quickly, Jordan. Yep.
That's in direct opposition of my attorney, Jill Polster at Cohen Law's interpretation. You know, again, I just want to say, like, a warrant article is a simple thing. An operating agreement is a simple thing. And clearly, there's a lot of confusion with everything else. So can we just agree to take that path forward now?
But what's our authority as zoning board of appeals to do any of those? What's our authority as a zoning board of
Well,
appeals?
who has the authority? You have the authority to overturn her decision. And then who would be the one who was able, a warrant article is something that we would apply to the town for.
Right.
And who would we submit that to? The CEO? Or any town official?
I believe you would, I mean,
Clerk.
the town clerk, I would think. And
Okay.
I mean, we're not the legislative body of the town.
I understand. I'm just trying to reach a resolution for my business and I'm trying not to escalate this.
And-
We don't want it escalated either, Jordan,
Okay.
but we do want to get to the bottom and make sure
I know.
it's done properly.
All I'm saying is that the operating agreement or the warrant article are literally the only way around this that like is gonna be. It's seemingly gonna keep everybody's interests satisfied. Because we're gonna keep disagreeing on the language of the grandfathering. Like I have a different understanding of how that works than other people do. I've been doing this forever. There was no such thing as a permit for anything when I started. We didn't even have cards. So it's, this is, we're coming from we're grandfathered, so we're like great grandfathered. been doing this so long, so I just want to figure it out. So
Okay.
what's the procedure from here? Do you,
We're gonna close this hearing.
Yep.
And then we're going to discuss things amongst ourselves.
okay,
We may in fact come up with a decision tonight, we may not, but
Okay.
that will not be the end of the road.
all right. Well, I thank you all so much for your time. If I came across with any frustration, that's for obvious reasons. And thanks again.
Anything else? If not, I'm going to close this hearing. Public is welcome to stay around. We're going to deliberate for a bit. We're going to develop findings of facts, discuss it, and decide what course we're going to take. So the hearing is now closed. One of the first things that was discussed was the fact that that the appeal was not filed within 30 days. My feeling is they've got to have the right to appear before us at some point. It's an administrative matter. In this case, I'd be willing to overlook it in the name of progress for the town. How do you feel on that? What are you overlooking? That they did not file the appeal within 30 days, because if we stand by that, then all of this discussion is essentially moot. That they should go back and refile an appeal.
I think we should discuss the merits of it anyway.
Okay.
I'm not sure we have the ability to waive the time limit. I don't know the answer to that.
Okay, Cliff. No, I appreciate that.
And I mean, we heard from the attorney, it's not required to say in so many words, this is my final decision. It clearly was final. His own March 19th email shows that he knew, he said, I'm going to appeal this decision, and then didn't do it. And I don't know if we have the power to waive that, but we can set that aside for the time being and talk about
All right.
the rest of it. And I think it's also important that we're not here to make a judgment about or pass a referendum on what seems very clearly to be the social value of the activity that he's engaged in. It clearly is helping a lot of people. It sounds like he's very generous with his own activities, but that's not the question in front of us. And we have to be mindful that we're not elected. We're not given the power by the people of Pownell to make legislative policy decisions for them. And that's democracy.
Yes, it is. What Jenny read off would seem to be, from my perspective, very clear.
Yeah. And I just don't read the Allen Hill letter differently. He says that he's grandfathered for cultivation of cannabis, but I don't think that's really, doesn't look like that's what this form is asking about. This form is asking, it looks like specifically about I think it's the extraction activity, the inherently hazardous substance manufacturing program, not growing plants. So,
Thank you, Jordan, but, yeah, sorry.
so I just don't read that April 2022 letter as speaking, as saying that Allen Hill would have signed this form. Or that Ginny was required to, or even authorized to. On the second page of the form, the third box, the sort of third yes or no question from the top was the IHS manufacturing facility operating with municipal approval prior to December 13th of 2018. I don't know. I haven't heard of anything that was a municipal approval of that kind of inherently hazardous substance activity. And so, I mean, I think it's very unfortunate, but I don't know that we have the authority to do anything about it. And it doesn't mean other officers of the town can't do something about it, but, or the people of the town can't do something about it, but I don't know that we can.
John, attested to the fact that, the select board became aware that, Jordan was in existence. But, that's a long ways from any type of approval. I know Jordan took that as an approval of some sort. I don't think we're in a position to do that without any hard and fast language of any sort. David, any observations?
Well, I'm just wondering whether, if this form is not filled out, is that going to, stymie Jordan from continuing his practice? Does he need this form to continue?
I believe his license ends on, is it June 28th, Jordan?
Yep.
Something like that.
Not be able to operate. Not the off extraction. Go ahead, real quickly, please. No,
So just my understanding of it. Thank you for.
yep.
Would it be any different, like, say, one are,
And then it would fall under commercial, kitchens and, OSHA would come in to apply. It would be a whole different ballgame. Corn and cannabis.
Not the question.
Because, you know.
Yep.
One problem.
Yep.
License, you can-
Yep,
you got on the way, but I don't think we need special license or whatever to make phone service.
but as I understand it, by state law.
I think we have to deliberate the.
Okay, yeah, you're right, yeah. I appreciate it, thank you. What else, folks?
It looked like the state was regulating this right along. And then when the extraction started, when you stopped, actually regulating that and leaving it to the,
I mean, in 2018, when, December, when they
yeah.
gave it over to the municipalities. I don't know.
The language change requiring that he get municipal
Yes.
approval.
That's what I get from the form.
Yep,
Yeah.
yep.
So that means we're supposed to, the town,
Yeah.
But we have nothing in the book to address it. We have nothing to go upon.
and what does extraction mean exactly?
Jordan, answer that.
Yeah, Jordan, you wanna, real quickly, please?
What extraction?
So there's two different extractions, definitions for extraction within the Maine Medical Marijuana Use Act and the Maine Adult Use Act, so. Well, I guess they're actually the same in both acts, but one is non-IHS extraction, which is anything using just like sifting through different size screens, or ice water extraction or anything like that. And then there's IHS extraction, which is a newly adopted term, which stands for inherently hazardous substance extraction, which would be using any number of light hydrocarbons, either butane or a mixture of butane, ice and isobutane, or butane and propane, or butane, isobutane and propane, It could include any, basically, it's anything. IHS is anything with a flash point below 38 degrees Celsius or 100 degrees Fahrenheit. And that's how it's defined. And again, always been allowable conduct as a caregiver in any municipality up until the new regulations, and no municipal approval was required until 2022 as part of the licensure. Any other questions?
No, thank you very much, Jordan.
Had an operation like that. Have Cited.
Sorry?
No, I'm just saying that if we had that, we'd have to cite that business somewhere that would be out of a heavily populated area.
We have 20 acres.
Jim, do you have any advice on this going forward? Not at this point, okay. Well, folks, we can either make a decision or kick the can down the road and meet again in another week in hopes of developing some additional supporting evidence or something.
I did hear from Mr. Smith's attorney that he wanted to submit us some supplemental authority or explanation of.
In response to your question.
Yeah. I think it would be helpful to see, I mean, here's what I think, here's the question as I see it, which is, I think if I understand Jordan's position, it's that somehow this IHS activity was something that the municipality had approved of, and that approval was sort of automatic by virtue of the fact of being a DHHS licensed caregiver at the time that he was, prior to December of 2018. And that since he was operating with municipal approval, like by operation of law, if I'm understanding the argument correctly, and that only became non-conforming when the state regulatory scheme changed. And I'm not judging whether that argument's correct or not, but it relies on some legal authority that I don't think has been presented to us. And I'd like to see it before I pass judgment about it.
You could provide. Okay. Through Becky. Just so that you're aware, the scheduling of a zoning board of appeals meeting is somewhat challenging. We have to post legal notices. We have to come up with an evening when we're all available, when we're assured a quorum. So, not saying that you have to have it in within the next few days, but whatever you can do to help us along in that matter would be appreciated. Anything else, folks?
Would it make any sense at all for one of us to present our dilemma to the folks who deal with this at the state level and tell them their issue we're having with the zone? We don't have an ordinance that really covers this. And then the grandfathering and all this, and whether what we need.
I'd like to hear from
change?
Jim on that. I'm not sure it would be appropriate for us to reach out in a non-public setting to people to take in information that bears.
Well, maybe the lawyer could.
Jim, what can we or should we do?
When this is all over and you have a decision, then maybe you might want to send it along as an example of what can happen out there, for some guidance in the future, but not in the middle of the proceeding.
No.
One thing is you could short circuit some of the notice issues if you would say that this was being continued to a particular date and time this evening. So I don't know when this room and when this board's members can get together again. But if you were to say a week from tonight or 2 weeks from tonight, everybody in this room would know when the next meeting is, and presumably they're the ones with the stake in this matter. you would still post it on the, you know, wherever you would post meeting notices, but it wouldn't be like you'd have to put a special newspaper advertisement in for this particular meeting. So it's just a continuation. Yep, we could do that.
Okay,
We could fast track it that way.
please.
Okay, Monday night, the select board meet, Tuesday night's election. So that might be a hard one for folks to get together. For me, I wouldn't be able to be here Wednesday or Thursday, but I could show anyone how to use a recording if you wanted to get that piece recorded. The following week, town meeting is Monday night.
What weeks are we talking about now?
So next week, I'm sorry, if we're thinking a week out, so next Monday is a select board meeting, Tuesday is election. But Wednesday and Thursday, I think, are open on the town calendar. The following Monday, the 17th is annual town meeting. And Wednesday is a state holiday, so the town hall is closed. But Tuesday, I think, would be open, or Thursday that week. I'm going off memory too of the town calendar.
I'm available the 18th.
So am I.
And I imagine it's too late for them to do anything at town meeting that could solve this problem.
That is correct. The warrant's already signed and posted. There's some state statute requirements for a citizen's petition, and it needs to be in 60 days before the town meeting. So the next option right now in the foreseeable future would be June of 2025 for a warrant article.
Are we looking at the 18th now? Is that where we're?
Does that work for most folks?
I think so.
Yeah.
Yeah.
Tuesday, June 18th?
Oh, is it? Okay, thank you.
What for,
Future Facilities meets on that night.
okay, who are they? Wait,
The 18th?
They usually meet in the voting room. Yeah, they usually meet in the voting room
okay,
downstairs.
so this space would be available.
The space would be available.
7 PM then on the 18th?
Yeah.
Tuesday.
7 PM, 18.
Do you want to set a date for any submissions of additional materials so that you get them in advance? The deadline for when those come in?
Yes.
Sure, what's a reasonable,
11th is 8 days from now and a week before the meeting. Does that work for?
Just please note, if they come in on the 11th, I probably won't get them to you till the 12th because we'll be running an election on that day, so.
okay, yep, we can work with that. Anything else? We need to formally table this hearing?
Let's continue.
Our continuation is at the proper, thank you very much. Motion to do such? Seconded?
Second.
All those in favor, please say aye.
Aye.
This meeting will be continued on the evening of Tuesday, June 18th at 7 PM.